Good evening from the San Francisco Bay Area, and welcome to Idea to IPO. Today, we're going to talk about how to position your startup company for venture capital funding. I'm Jason Putnam Gordon, an emerging growth and venture capital attorney with K&L Gates, LLP. K&L Gates is a fully integrated global law firm, which means it's on 5 different continents in 48 offices with nearly 2,000 attorneys. I am an emerging growth and venture capital attorney. So that means I work with startups and growth companies as they scale from formation through their financings, through their exits. And again, we're here today to talk about how to position your startup for venture capital funding. Let me give you a little bit of background here. I'm running all the tech in the background. So if there are any pauses or tech snafus, I got to sort them out. So bear with me. I've been doing this for a few years at this point, so usually they're pretty smooth, but I like to at least let you know that. Today's presentation is recorded, so please don't provide any confidential information. This is a public venue, and it's going to be recorded and loaded up onto the internet, and specifically YouTube, so it'll be around perhaps forever. Now, because it's being recorded, if you miss some or all of it, no problem. So long as you have registered, we'll send you a follow-up email with a copy of the recording. So of course, the corollary to that is if you're watching us and it's not live, thanks for watching. We're still very thankful to have you here in the audience. Now, speaking of audience, I've got an audience poll set up. Please take a minute or two right now to get that filled out. It's really helpful to know who's in the audience today. One other comment, which is if you've got any questions or comments, please use the Q&A function. Because I'm running all the tech and I got a bazillion windows up, I'm not going to be monitoring the chat. I might type in the chat from time to time, but I'm not going to be monitoring in the chat. So let's get started. Now, as I said at the top, I'm an attorney, and I wouldn't be much of an attorney if I didn't give you a few caveats. So please understand, today's presentation is not legal advice. We'll be talking about rules. We'll be talking about exceptions to rules. We'll be talking about fact patterns, and we'll be talking about different data points that I've seen, but it may not be applicable to your situation. So what you'll need to do is you'll need to engage with legal counsel who's competent and focused in that particular area, specifically emerging growth and with venture capital companies, at least with what we're talking about today. And that person is going to need to review all the facts and circumstances before they can provide you with your own legal advice. So that means even if I answer a question today, or, I do keep office hours, so feel free to connect on LinkedIn if you just want to connect, if you want to reach out because you want to take advantage of the office hours, to have about 20 minutes, just talk about whatever, general venture related issues, especially on the sort of legal side that you are facing or thinking about. None of that is to be legal advice. Again, we need to do conflicts check and engage, and then I'd have to actually weigh all the facts, but always happy to provide general information and share with you the wealth of knowledge that I've built up over the last, well, I'll tell you, over 10 years. So actually, I guess at this point, it's kind of going back to 18. Anyway, off the cuff answers to your questions are not and should not be taken as legal advice. I think I have now, reiterated that enough. So let's talk a little bit. Who am I? Why are we talking today? We're going to be talking about, here's the roadmap. So we're going to talk about my background to give you a little sense of who I am. We're also going to take a poll, at which we're doing right now. And please take a moment to fill out the poll because I want to know who is here in the room today. And we've got a lot to cover, a lot of great stuff. I'm basically going to tell you how to position your startup for venture capital financing, which means, wow, we got to kind of get you at a high level from formation to that, initial negotiation for the venture capital financing. So you got a lot of information to convey to you today. Great stuff. It's always really a pleasure to share this information because I find it's very helpful for founders. Now, We'll cover sort of structural considerations. We'll talk about the typical financing stages. This is like real basic background information, but it's so critical and so important. And there's a lot of information out there on the internet these days, but it's not always really distilled in an easy to follow manner. We'll talk about sort of documentation for those founders and early employees and other service providers, so you can get a sense for like, how is it that this thing kind of comes together and how does it grow? We'll talk about the initial financing that you'd likely need to obtain and how to do that, right? Via either a safe or a convertible note, using convertible, in other words, for convertible debt. And then the all-important, ever fearful thing, which is dilution, which of course really comes from, the way the game is played, if you will, about step-ups in valuation, that is increases in valuation as the company grows over time and hits its milestones. And then, of course, we will talk about give you an overview of venture capital financings, which I think is really critical, because if you want to know how to position yourself, you got to know where you're going. And then, to the extent we've still got a bunch of time, we'll handle any common pitfalls, and we'll take any questions and answers. So I'll talk for about an hour. What I'd like to do is, if you've got questions, use the Q&A function. I will probably be stopping periodically through today's presentation. And I'm going to try and take topical questions at that time. To the extent there are questions that are maybe not on topic, but are of general applicability, I will save those for the end. Again, we're going to be trying to hit those questions that would appeal to a broad audience. And one more plug, fill out the audience poll. Last 30 seconds to do so, and let's cruise right on. All right. So I am an emerging growth and venture capital attorney. I've been practicing law since 2005. I've been in the Bay Area since 2007. My office is in San Francisco, but I work with companies throughout the US and the rest of the world. Now, why is that? Well, because tech and venture always inevitably seem to touch the SF Bay Area. So it's a privilege and a pleasure to get to work with folks from all over the world. And I love working with entrepreneurs on financings as their outside counsel, and also on exits, right? That's an M&A transaction, or, should you get there, an IPO or a SPAC, et cetera, et cetera. Then one other piece of information I'd love to share is that, I'm a bit of an entrepreneur myself. Before I returned to big law, I ran my own practice for about 5 years. So now I know what it's like to take something that's just an idea in your head and actually take it and grow it. And I find that advice has really resonated with my clients, and it's made me a better advisor. So with that in mind, let's talk and find out who's in the room. Last 10 seconds to fill out the poll. All right, let's see here today. So we got about 20% of the folks from the Bay Area, and 14% from elsewhere in California, and about 40% from elsewhere in the US. So I'd say probably in the aggregate, we've got roughly 70%, because I'm kind of rounding up on some of these things. Between 70 and 75% of the folks are from the US or Bay Area. We've got some folks from Europe. Thank you for staying up, or thank you for waking up in the middle of the night. Really appreciate that. We'll try and earn your time. And also same for those folks in Asia and Australia. In terms of the composition of the room and where everybody is in the development, in the ecosystem, we've got nearly 50% are first-time entrepreneurs, which is not a surprise. Love to have you here. I feel like you will benefit quite a lot. And of course, there are about 20% who are serial entrepreneurs. And even those folks who are serial entrepreneurs, entrepreneurship is an amalgam of skills, right? So it takes time and practice and study. And I frequently get comments from serial entrepreneurs that, yes, attending these events is very helpful for them. A few angel investors, and then we've got some folks from somewhere else. So delighted to have you here, either live or if you're joining us on a time-shifted basis. Fantastic to have you as well. Let's talk about some of those structural considerations, if you will. All right. I'm not going to bury the lead here, especially for US-based startups, okay? And that's kind of what we're focused on here today. I'm an attorney in the San Francisco Bay Area, more specifically San Francisco. most of the audience is in the US. I think we said 75%. We're going to end up with a Delaware C-Corp for a venture-backed company. And I'm going to explain why that is. For those of you who are outside the Bay Area, this will likely not apply to you directly, but I will tell you that, sort of this model has moved across the globe. So I think you'll still get some value out of this. And if nothing else, you'll kind of understand the landscape a little bit more. So let me tell you a little bit about how and why you end up with a Delaware C-Corp 98, 99 plus percent of the time. There's what I like to call the matrix that you take a look at, okay? And there are roughly 7 items that we kind of take through, whether any business, any entrepreneur who comes into my office or virtually these days we meet, we run their business plan through the matrix. And the matrix involves taking a look at what the tax implications of are the structure that they're going to be setting up, the liability concerns. Now, liability concerns are concerns about protecting your own personal assets, your house, your car, your credit, from any liabilities that might accrue in the business. And if you are a sole proprietor or you've got a partnership, that's potentially unlimited liability versus setting up a corporation or setting up an LLC or setting up a limited partnership. We think about and we look at ownership structure and equity grants. What is that capitalization table going to look like? The capitalization table meaning like the owners of the company. And we think about the capital raising requirements that your business is going to have. And let's talk a little bit about companies that are venture backed and that are well positioned to be venture backed. Well, usually those are companies that are going to require a tremendous amount of capital to grow and scale. They'll be able to grow and scale in 5 to 7 to 9 years, roughly. And they'll be raising successive rounds of capital, kind of tied to milestones, right? So in your business plan, it's like, and we could see this right here on the startup financing cycle here. Initially, you're going to be raising seed capital, put together your prototype, get the initial team together. And at some point, you're going to start maybe being able to sell. And at that point, once you demonstrate market traction for most venture-backed companies, now it's going to be a little bit different in the life sciences area. For example, if you're working on a drug, you're going to need to be able to go through, the different approval levels, clinical trials, et cetera. But, if we're talking about most venture-backed companies, this is what we're talking about. And it's kind of at that point when there is demonstration of market traction. That is, you've got customers, that product market fit. There are customers out there who are interested in your product, want to buy your product. And really what's sort of holding growth of the business back is not product market fit, but really the ability to satisfy demand that the market has for your product or your service. That's when the VCs get really excited. And those funds, are set up with, a particular play in mind. Basically, they last for roughly 10 years or so. They'll be deploying capital in their first years. They'll be making investments in companies that, have the potential to really hockey stick. And they're looking for, they want each company to be a winner, but they're looking to make the return on their portfolio by just a couple of great wins. And, that's kind of a topic for another conversation. But again, we talk about your capital raising requirements. So to bring it back to the matrix, we've talked about taxes at a high level, liability at a high level, ownership structure, capital raising requirements, management requirements, right? So who's going to have a stake in management of the company? And most of the time when you're raising capital from venture capitalists in this ecosystem, at some point you're going to end up with a venture capital board member, or most likely ultimately multiple board members. We think about the exit, and we also think about the regulatory framework that your business would be in. So not all businesses can be Delaware C-Corps for regulatory reasons, and many of those sort of exist potentially in the healthcare space. And so with that in mind, again, it's not all the time that you'd end up with the Delaware C-Corp, but we run you through the matrix, we take a look at it, and 99% of the time, that's what we're going to end up with. Now, on the capital raising requirements side, one real reason that there's a push is because that's what the investors are going to want. If you're going to be raising from venture capitalists, they're set up as a limited partnership. That's a pass-through entity, which means the profits and losses that entity incurs gets passed through to their limited partners, which are their investors. And it would be a tax and accounting nightmare if they were to invest in a pass-through entity or a disregarded entity like an LLC. Why Delaware? Well, most large corporations are headquartered there, especially publicly traded corporations. That is one, sort of typical goal or path to liquidity. That is path to getting cash back that these types of companies pursue. And so, kind of keep your eye on down the road where you headed and then work backwards. Delaware also has great, or is generally speaking, more robust liability protection for directors and officers. So that venture capitalist has a board member, a seat on the board, they're going to want additional protection. And the Delaware Secretary of State's office is just fantastic at pushing and moving corporate documents and filings through, which if you're trying to get a merger or financing done is pretty critical. So I'm going to pause here. If you've got any questions or comments on this, please submit them in the Q&A function, and I'll see, I'll try and take them. Otherwise, we'll move on to founder and early employee documentation. It's very exciting. Okay. Fantastic. So we talked about the matrix, talked about why Delaware. Oh. The question is, how is Delaware different than any other state? Delaware is different than any other state because most of the large corporations and most venture-backed companies are already based there. So that already sort of sets, to a certain extent, a little bit of the status quo. Further, the statutory law there, the Delaware General Corporations Law is is generally speaking more favorable for companies and very business friendly. Further, there's the liability protections for the directors and officers, which I mentioned before, and the Secretary of State's office is very good at moving paperwork through. So kind of on balance, those are several differentiating factors from other states. Further, and actually, let me go back to the first one. It's sort of, to a certain extent, because most people set it up this way, that leads to most people saying it up this way, so that when an investor is taking a look at your corporate books and records, et cetera, and trying to understand, the corporate legal structure, because they have done so many repetitions with the Delaware state, and their lawyers have done so many with Delaware, it makes it much easier for them to review and spends less time. So that's what we see rather than, California or Nevada companies. And no, they're not the same. There's a question in here about what happens if you set yourself up with an LLC. Don't panic. It's possible to potentially either convert the LLC to a corporate, first you got to run it through the matrix and make sure it makes sense to change it. But if you need to change it, there are ways to do that, which would involve potentially either a conversion or a merger. Got a question about regarding protections. Isn't where the company is operating also relevant when it comes to how legal issues are resolved, i.e., not just where it's headquartered? Great question. Out here, and this is actually a subject that is an open constitutional question, as in the United States Constitution. But yes, of course, it's relevant where the company is headquartered as well, or where the employees work, right? Employment law is going to be based on wherever those employees are working. But, at least on the corporate law, there are some things that can be helpful to set up for Delaware. So for example, in the certificate of incorporation, you can put a provision in there that to the extent there are any disputes that relate to corporate law, they must be heard in Delaware. So you can kind of protect around that and sort of get a choice of law out of it. You can choose Delaware that way. Okay. Moving on. I do see there's we can come back and maybe hit this topic, but there's quite a lot to move through. So let's talk a little bit about founder documentation and early employee documentation. So what this is really sort of about is making sure that the intellectual property gets tied into the company and the company owns the intellectual property. That's what I mean by tied. And to the extent somebody has some sort of interest in the company, an ownership interest, which would be kind of on the equity side, or a debt interest, all of that is getting documented and papered and has been properly approved, gotten the proper corporate approvals, and been properly entered into. So, typically here's what we see. There's going to be intellectual property assignments up and into the company by everybody who works for the company, either as an employee or as a consultant, kind of in any and every capacity. In terms of taking an ownership interest, we typically see that early on in these companies' life cycles, they will sell stock to their employees or officers or other folks, directors. It'll be restricted stock, which means that there are going to be some restrictions on it. One of those restrictions is going to be vesting. So vesting means, vesting, people sort of think of vesting as being like you get your shares over time. But the way I actually really think about vesting is like you get all of your shares up front, but they come with strings. And as time goes by, the strings get cut. And that's so that if you end up leaving, you walk away with what doesn't have strings attached to it, more or less. But that's to prevent the scenario where, you got a co-founder or early employee who gets a big slug of equity or even just a meaningful slug of equity, and it's not subject to vesting. So they've got it and they own it forever. And then, they're only there for 30 days. Now, not just the 30-day scenario, but they're not there long enough. And the rest of the team, I think the statistics are, from formation to your first institutional round is on average 3 years. There's a lot of time that has to get put into these. So it takes time. You want people to be motivated and have skin in the game for the long haul. And sort of the flip of that is, especially if somebody leaves under circumstances that are less than desirable, you want to make sure you don't end up with, for example, a competitor on the cap table, right? On the capitalization table. So there are various transfer restrictions that we would get in place to prevent that. And those can end up in either shareholder agreements or in the bylaws, or, again, if you've got, you do a restricted stock purchase agreement, many times it's handled in there. I see there's a question about the break-even point on the structural table. Like that is just meant for illustrative purposes. It's going to be different in every business as to what the break-even point is. But it was just going to show that, like, at first, the company is just, no revenue. Start, put together the team, put together the product or service, go to market, start to get some traction, raise some funding, build out, in accordance with their business plan, to hit, gets to a point where it hits the next milestone, gets another round of funding, sets, et cetera, et cetera. And that, happens over successive rounds. All right, financing options. So for those the initial sort of seed round, build out that initial team, get that initial technology or product together. Usually what we're going to see is that rather than doing a sale of common stock, which can create a number of problems in terms of sort of valuing the company. And one of the issues with valuing the company too early is that if you're the founder, you undervalue the company, then you will have sold too much. If you are an investor and you don't value it, and the value is too high, then you've bought too little. And they're very difficult to value very, very early on. And in fact, actually, most people ask, kind of how is it that early stage companies are valued? And there are various methods out there, like the Burkus method and other things like that. But what happens typically is, aside from maybe some comparables, what will happen is on the early stages, to the extent the company gets valued, it's really sort of a negotiation around how much capital does the company need in order to hit, a specific milestone that would then open it up for, allow it to then scale further before hitting additional milestones. And so again, it's how much capital does the company need and what percentage of the company is it willing to sell? That's typically what drives those initial financings, rather than a sort of discounted cash flows, or other sort of more traditional financial metrics. Now, again, so typically you'd see either convertible debt or convertible equity. We're not going to spend a whole lot of time getting into the intricacies of this. I've got another presentation that goes into it. I'm happy to share it with you. I've been working on a resource that's an on-demand video resource. And I have sort of a limited beta open right now. It's called Venture Capital Training Camp. If you want to sign up for that, we actually kind of go through each of these topics, in sort of 8-minute video chunks, explaining them, going quite a bit more in depth. Feel free to check it out. If you've got thoughts or comments on Venture Capital Training Camp, again, it's still in limited beta, going to reshoot it this year. And it's free, at least at the current time. So looking for feedback because we're sort of beta testing it. Yeah, so convertible debts, convertible equity, also known as bridge notes. This is basically a mechanism to prepay for the preferred stock. And the sort of thought process is, when you're going to actually you're going to do that venture capital round, that's when the company will be sort of large enough to have a more appropriate valuation. And in connection with that, what we really need is some sort of instrument that kind of bridge us or get the company from where it is right now to that venture round. Although even many times that initial venture round is going to be driven by how much company the capital needs and how much of the company is willing to sell. Now, convertible notes do not have a standard form. They just don't, which is great. And it's also kind of terrible, just because people say, well, give me the standard one. There is no standard. Even safes, that is simple agreements for future equity, those were put together by Y Combinator. In one sense, they are more standard, but even those, they typically get tweaked. And then, we talked about why you don't usually use sale common stock initially to raise funding. We talked about the two mechanisms that you do use typically, either either a safe or a convertible note. And the other is venture rounds. And we'll talk about those preferred stock rounds in a little bit. I think we've already covered some of this. Convertible securities. So we're talking about those safe instruments, which also sometimes are called convertible equity. And we're talking about convertible notes, or what I've also called convertible debt. Mechanism here, or the point here, is to convert that sort of principal amount, and maybe interest if you've got a convertible note, into equity securities at a discount in a future qualified equity financing, more specifically a preferred stock financing, right? Which is presumably led by like a venture capitalist. The reason why this is done is that it avoids value in the company. We just sort of talked about the perils of that. It's also far less expensive to do than a preferred stock round, like a Series C or a Series A round. And some of the downsides here are, at least with respect to convertible notes, and I'm kind of talking from the company's perspective, not the investor's perspective, but from the company's perspective, is that it is debt, which means it might be, maybe required to be repaid at some point. It also will have an interest rate feature. And, in the cap stack, the capitalization stack, debt gets paid first before equity. So if the company liquidates and there's not enough, let's say there's $1 million of convertible notes out there and the company gets sold for 500,000. Well, that 500,000 is going to get split up among the convertible note holders. So they're not going to get made whole, but at least they'll get some. And then, the folks who have common or who have equity, they're not going to get anything. So that's sort of potentially one of the downsides there. Or if that company, for some reason, did have preferred stock, the convertible notes would get paid first. Someone's asking me for what the name of my sort of beta test limited program here is, and that's Venture Capital Training Camp. I'll put another link in the chat here. And I'm going to take a couple more questions and also take a drink of water. Someone's asking about what other states like Nevada or Wyoming, those do get set up. But again, like I'm trying to lead you through the more traditional 99% of the time. And then many times actually, and some of these, one of the entities listed here is actually an exchange, and that's actually a highly regulated field. And so that's a little bit different. When you run that through the matrix, you're going to end up with a little bit of a different outcome potentially. All right. And I didn't take my water yet. Let's see. So what are some features and terms that these convertible securities have? And again, like this is the well-worn path. We're trying to get you, trying to describe and elucidate how to position your company for a venture capital financing. So like high level, that is, look, there's a well-worn path to setting up these companies and doing their initial financings. That's what those venture capital investors are going to be expecting to see. Now you can have something different. If you got a product market fit and you're just killing it and they're going to be able to make the return that they are looking for, well, you may very well be able to cut a deal. And sometimes in cutting those deals, you need to then shift it. So I can't tell you the number of times that I have, folks have done something on their own, or they've worked with other counsel and they've got themselves set up with an LLC at first, but they got a great product. It's out there in the marketplace. There's a lot of traction. So they're going to be able to raise venture capital financing. They get a term sheet, but in the term sheet, it is, you got to convert to a Delaware, or you got to merge over, you got to change the entity form to a Delaware C-Corp ahead of closing or in connection with the closing. So again, we're talking about US companies. So you can have something else out there. And you may even be able to raise VC off of it, but how to get you there? Let me tell you what the well-worn path is rather than those side cases. Now, in convertible securities, what are you going to see? Well, if you got convertible debt, you're going to see a maturity date. That's the date that the loan is due. And you got an interest rate. Now, there's a lot of other stuff that can be in there, but these are sort of the big ones. And you're going to see conversion terms, and we'll talk about conversion terms in a minute. And I'll even kind of provide you with some information on how they work. We'll go through some examples. Another, and conversion terms will be in both safes or convertible notes. Amendment terms will also be in safes and convertible notes. And one really important thing that, it's kind of like a pitfall, is you want to make sure that, you're going to have, the company would have the ability, and the investors by and large should want this as well, have the ability to amend that convertible security based on the holders of a majority of interest of those outstanding safes or convertible notes. So if you got $500,000 of safes out there, so long as you get safes that are equal to $250,001, you can get an amendment passed and through. And you want that because something might happen that you need to amend a term. It happens very commonly in convertible notes. You bump up against the maturity date. And so the company's got to pay the money back, but the company doesn't have the money. So what do you do? Well, unless it's handled otherwise in those notes, you got the danger that investor could put the company in bankruptcy, or you can amend it, and push back the maturity date. Same thing too, if you have, for whatever reason, cut too sweet, or there's some sort of issue, if you, and I've seen these too, if you've had some sort of safe or convertible note that's outstanding with like a 70% discount, that might wash out the existing founders and other folks, and the new money is not going to want that. They want those folks to have, those founders to have enough skin in the game. And so that might need to get amended. Remaining terms, they're not as common to heavily negotiate them, but you got to watch out for some weird pitfalls and stuff. Like, for example, out in this ecosystem, at least in the US, and I've worked deals that are outside the US as well, in connection with working with local counsel, there is no personal liability for safes or convertible notes. In other words, the founders are not going to be personally guaranteeing the repayment of the convertible note. Now, I guess there could be personal liability if, that founder were out there and were a fraudster, and there were other forms of liability it could attach, maybe for claims of fraud or other things. But in terms of the convertible note, if you get a convertible note with a personal guarantee on it, that's usually a red flag that you're dealing with somebody who's not familiar with this particular market. And it can make it really hard and expensive to negotiate with those people, because they've got something in their mind, and it's kind of a little bit of an adversarial situation, and it'll be hard to convince them otherwise. Now, conversion terms, we talked about this. How do you take that outstanding note or that outstanding safe and change it into shares of preferred stock? Well, there's a term for that. And, that's the mandatory conversion. That is mandatory, meaning it has to happen. And there's going to be a discount. And that's going to happen at the next qualified financing. Qualified financing is typically defined as an equity financing or a preferred stock financing. And there's many times a threshold in there, although I don't believe that's in the current form of SAFE. But a threshold of some size, so that you can't have your Uncle Harry, do a financing for $50 and value the company at $200 billion, effectively just sort of washing out those safe and convertible note holders. As noted before, there are two different kinds of discounts here. There's like the percentage discount, and then there's what's effectively a discount called the conversion price cap. And we will walk through kind of the mechanics of that. But the concept behind that is, at the preferred stock round, actually, we'll get to it when we get to the math, because it's easy to explain. It's easier to explain with numbers. Now, sometimes there are also conversion terms that go into effect if the company were sold or liquidated. And then before I mentioned earlier today, I mentioned, oh well, many times companies will bump up against the maturity date in a convertible note. How do you handle that? Well, one way is to get an amendment and push it back. Another way is sometimes there are provisions that will handle that in terms of converting it into common stock or converting it into sort of a pre-agreed upon form of preferred stock. All right, I'll take some questions of general applicability. Still more, yeah. Okay. Question about, are rounds of funding guaranteed when the company hits particular milestones? So typically, no. Sometimes we'll see around, typically no between rounds. Sometimes we will see rounds where an investor is a little concerned. I think this is like a great company, great team, but I'm not sure they'll be able to execute, maybe even for circumstances beyond their control. Let's just say, for example, it's in a field where they need to go out and get a government license for something. So the investor will kind of hedge or kind of, get some protection from some risk that they will, that they don't get the license. So for example, if the investor were interested in putting in $5 million, but they can tranche it or put it spread like, 2 million now and 3 million after the company obtains the license. Sometimes we'll sort of see those types of milestones built into the contract. And then it would be, contractually obligated for them to fund. But in terms of like next rounds, no. Because interestingly, a couple of things here. So investors will specialize in different stages of the life cycle. So there'll be, investors who play primarily in the seed stage, investors who play primarily in the early stage, and then sort of like the growth to late stage. And so you will actually kind of be many times moving through different sets of investors as the company moves, goes through time. Now, one way that investors do protect themselves and reduce risk is, they will not put all the money that they could invest into your company in that first round. So they'll hold some back for like another round. And we'll talk a little bit more about this probably when we talk about side letters, but that's where the issue of like pro rata rights comes in. And that's why that's important to them. Question about going deeper into safes and valuation caps. We will not get to that today, but do check out, I've got a whole sort of module on safes and convertible notes and valuation caps and like spreadsheet analysis on how you do pro forma cap tables in venture capital training camp. So yet another plug for that. What's the difference between convertible notes and warrants? A warrant is basically like an option to buy shares of stock. And so, but a convertible note is a debt instrument, a blend of debt and equity instruments. So you actually get the capital in the company sort of right away. Sometimes we'll see a warrant or basically a convertible note issued with warrants on top of that, which is a way to kind of provide a little bit of upside to the investor. But that's kind of going beyond the scope of today's conversation. Okay, great. So let's just talk a little bit about valuation basics and dilution. Founders are very understandably concerned about dilution, right? That is, the relative ownership interest in the company is going to decline over time. That is because, you start out with a certain amount of stock. The founder, well, we'll go through this in a minute. You start out with a certain amount of stock, and then more stock gets sold over time. And you calculate your ownership interest by taking whatever the number of shares that you own and divide it by the number of shares that are outstanding, at least on a fully diluted basis. Now, a concept I want to make sure we all get on the same page as, and I think this is the best sort of general definition of it. Everyone kind of has different definitions for these things, but Pre-money valuation of the company is the value of the company before the new money comes in. Post-money is the value of the company after the money comes in. So in other words, you should be able to take the pre-money, add that investment money, and that should get you the post-money. When we're talking about fully diluted basis, we're basically talking about all common stock issued and outstanding, plus all securities that can be converted into common stock, plus typically anything that's reserved under the equity compensation plan. We're not talking about authorized stock, authorized shares. Again, if you're really interested in that, you can check out Venture Capital Training Camp. We spent a lot more time going into it. So let me give you a very, very simple example. And I'm not going to take into account like option pools or any other equity outstanding, but let's just say there was a company, and let's just say its pre-money valuation was $10 million. And in that company, and I'm not saying you should use these numbers to, split up the shares among yourselves if you've got, you're forming a company, but let's just say there were 10 million shares split up among 3 founders, and nobody else owned any shares in this company, and nobody else had any options, and nobody else had any warrants, and nobody else had any convertible notes or any of these other things at this point. In that case, founder A would have 3,333,333 shares, or roughly 33% of the company. If an investor were to come along and invest $3 million, we'd want to know what they would pay. So what the typical calculation is, you take the pre-money, you divide it by the number of shares that are outstanding, and that's what they're going to pay. They're going to pay $1 a share. And so the post-money is that $10 million pre-money valuation plus their $3 million, gets you $13 million. Now, as I was saying before, dilution, founder's relative ownership interest goes down because more shares are outstanding. Founder A still has the 3,333,333 shares, which is roughly 25% of the company, because now there are going to be 13 million shares that are outstanding. But the upside is that those shares at least have a paper value of roughly, over $3 million, right? Because it's $1 a share. Now let's put in an example with a convertible note, and we're going to ignore some circular math and some other things that go on. And if you're interested in that, and understanding, circular math and turning on, going in Excel and turning on iterative calcs and how we actually work through this, check out Venture Capital Training Camp. But if there had been a convertible security or convertible securities that were totaled $450,000, and there's a 25% discount, and the new money, for whatever reason, ignoring some of the back end math and other things and circular math, we're still going to be paying $1 a share. Well, in which case that $450,000 convertible security would basically convert over into 75, at 75 cents a share, right? So it's that $450,000 divided by 75 cents, right? 25% discount will get that person 600,000 shares, shadow shares. Shadow shares are almost exactly like what the new money is getting, but there is a adjustment for the liquidation preference. That is how much money the company, that those folks would get if the company liquidated or sold, the preference there. Dividends, and also their anti-dilution protection, because they're actually getting their shares at 75 cents a share, not $1 a share. Similarly, let's use the cap here, right? So we talked about one mechanism, which is the discount, and then the other mechanism is this cap. If there had been a $450,000 convertible security with a $5 million cap, that cap basically means ignore whatever the pre-money is. Once you get up past the cap, and the math actually is a little bit different if you've got a cap and a discount, but for a cap only, once you get up past the cap, you ignore whatever that pre-money valuation is. You just pretend that pre-money valuation is what the cap is. That's 5 million. So you see, actually, they would get their shares at 50 cents a share. That would be the $5 million cap divided by the 10 million shares that are outstanding. And you'd see that in this case, the investor would get $900,000 with the cap. All right, so we've got about 10 minutes left. I'm going to move into the overview of venture capital financings. And then we've got, half hour at the end to take questions. So appreciate all of the participation today. Here's my take on how to be successful and how to approach venture capital financing. Make sure you put together a credible business plan with milestones. We've already seen at the outset of this talk that, there's a well-worn path. The company will raise capital in successive rounds. They'll be using that capital to do certain things, right? Put the initial product together, initial team together, put maybe the initial sales team. Maybe it's like, next level is to, move it, expand into this other geographic market. Maybe it's to expand their, your production facility here, something along those lines. Put together that stuff. And then run a systematic process and make sure you do this when you got enough gas in the tank, when you got enough capital already. Because what you don't want to do is you don't want to end up getting, having a lack of capital be leveraged against you. In other words, you're running out of cash, and if you just don't take a deal, you're gonna go under. In which case, that you don't have much leverage. Then run a process to connect with investors. There's a lot of information on investors out there. I don't know. I've kind of gotten into reading on Medium. There's a lot of people with a lot of opinions. Okay. I'm also a person with opinions, obviously. Hopefully you're finding them educational, maybe even mildly entertaining. And that's why you're spending time with me. But, it can take conversations with 40 investors to find one, 50 investors, 100, right? Build that funnel and run a process. Have background information on them. Maybe you break it up into, these are my safeties, these are my target, and maybe these are sort of my reach investors or my ideal investors. Understand, and we'll talk about term sheets in a minute, but understand what your ideal term sheet is, and then test the market, see if you think you can get it. Now, maybe your ideal is unachievable, so you need to adjust your expectations, but work with that. And be prepared for thorough diligence. That means that be prepared for the investors to scrutinize your business plan, to have their attorneys scrutinize the books and records, every book, every record of the company that you've got. Be prepared potentially, especially if you've already got customers, for them to do interviews of your customers, or at least be mentally prepared for that. And be prepared for some cleanup, corporate and other things. No company, I would say almost no company, effectively, no company is perfect. And in connection, and especially early stage companies traditionally, and in many senses appropriately, really focus on product development and getting to market, as opposed to having squeaky clean books and records. Obviously, I want you to have squeaky clean, any lawyer you work with is going to want you to have squeaky clean books and records. And yet also there's the practical reality and so long as you're making informed business decisions as to what that level of risk is, it's going to be what it's going to be, but be prepared to have the investors insist on cleanup. Sorry, I'm just taking a look at some of my notes. Okay. Now, again, you can also check out Venture Capital Training Camp, because I think I have like 12 videos on preferred stock financings. But I'm delighted you are here today, either live or on recording. Understand your ideal term sheet. So first and foremost, understand how much of the company you're willing to sell, and for how much capital. And that's, again, getting back to many times these initial rounds are, not the value of the company is not based on a financial metric. You can take a look at comparables. You can use some of these other, methods that are out there, but many times it's basically how much of the capital does the company need and how much is it willing to sell? And that's kind of what's getting sold. But you also kind of need to next level it by running, pro forma cap tables. That is basically estimating what it's going to look like when you close that round, and then ideally the next round. And that's because, as you've seen, when those safes and convertible notes, you don't know what those safes and convertible notes are going to convert into until it happens, right? Because it's going to be dependent on the pre-money. And it's going to be dependent basically on the pre-money, right? So if you got that discount, that impacts it, or you've got that cap, that also impacts it too. Or if you've got both, you got to run the math on it. And I will tell you, many times founders and entrepreneurs haven't done that, and they are shocked to see, going into it, they believe and feel like they've got 100% of the company, and they say, well, we'll sell 20%, so we'll have 80% afterwards. Well, it's not going to shake out that way, because you're going to need to have an option pool, either because you got a stock option plan or an equity incentive plan. So that's going to take up 10% plus or minus, 5% or so. You're going to be selling those shares to those investors, right? That's another sort of 20% there. So there's going to be safes or convertible notes that are being converted over. So, it is not unusual to be in the 70s, 60s, 50s, and sometimes even a little bit lower than that, especially if the company's been around for a long time and done multiple rounds of safer convertible note financings. Understand how much the company is being sold. There's going to be a negotiation around dividends. That's not normally highly contested. The funding environment has been changing. So, it's still been, especially in the early stage, fairly company friendly. But, that's changing. That's changing with respect to valuations a bit. Some liquidation preferences also getting impacted a little bit. Voting rights, what rights do the preferred stock have the right to vote on? What blocking protections do they have in terms of the protective provisions? Under what circumstances is it mandatory that the preferred stock convert to common stock? Under what circumstances is it optional? Anti-dilution protection. So if the company has a flat or down round, okay, are those investors getting sort of topped up in terms of the number of shares that they have, or more technically, the number of shares of common that their shares of preferred would convert into? Vesting for founders. So if you haven't gotten yourself or your co-founders set up with, and other key employees potentially, if you haven't gotten folks set up with vesting, or if you have had vesting in place, but it's all substantially vested, you may need a reset on that. Who's going to be documenting it? On the West Coast, it's typically company's attorneys that draft. Elsewhere in the US, about 50-50 company attorney versus investor attorney. And sort of same outside the US. Attorney's fees. So it would be expected that, some of the investors' attorney's fees will be covered, and that's negotiable how much. And then no shop, meaning you can't take out the term sheet out and shop it to other VCs and try to get a better one. And board seat implications. And I know there's a question about board seats in the Q&A, and we'll hopefully touch on that shortly. Overview of venture capital financings. Let's talk about like the mechanics. So we talked about negotiating, hopefully you form the company properly. You've taken care and, secured your intellectual property, the ownership interests. There are great commercial agreements in place. There are the right kinds of agreements in place with employees and consultants and suppliers and et cetera. You've raised, most likely through safes or convertible notes. You've thought about your preferred stock financing. You've thought about what the ideal term sheet is. You've run a great process of identifying investors and moving them through the funnel and the pipeline. And you're about to sign a term sheet. What does that look like? What does it look like from here? Well, there's a thorough diligence process, which I've already mentioned, which involves them taking a look at your business inside and out. Business plan, potentially talking to customers, reviewing books and records. And, that data transfer usually happens in what we call a virtual data room. So it's, many times we host it, but it's kind of like a box or a Dropbox type set of folders. Documentation process. Again, we talked about drafting. I would say most deals these days are either based on the NVCA forms. I'd highly encourage you to take a look at them if you're curious. They're, 5, 6 agreements, hundreds of pages. You don't need to look through them, all of them, but if you're curious, look at them. There's also a form of term sheet. It might be very, very helpful. I think their form of term sheet's like 10 or 14 pages or something like that. Many times, it's going to be the VC or the lead investor who supplies you with a term sheet, and you'll be working from, that form, but you'll at least get a flavor for what those term sheets are. Other things we still see are forms of documents on seriesseed.com. There are pluses and minuses to all of these. We're not going to be able to go into them today, or maybe in the Q&A if you've got further questions for it. And then sometimes some firms have their own proprietary forms, but that's really kind of changed in the last 5 years or so. You move through diligence. At the same time, there's this documentation, there's exchanging of drafts back and forth. Closing is when you got all the documents, all the diligence completed. The money comes in, the stock gets issued, and then there are post-closing items. And those post-closing items, include securities filings. Sometimes there will be covenants or promises that, things that the company needs to do after closing. So you got to track those and do those. And that kind of wraps it up in a very high level. Again, if you want to learn more, you can check out Venture Capital Training Camp, where we spend a lot more time going into depth in each of these. Again, it is an educational resource, not meant to be, it is not going to tell you, it's not going to be able to allow you to be me, basically, or another venture capital, emerging growth or venture capital attorney. Common pitfalls. So non-compliance with securities laws, including using finders. Finders are people who will say they'll go out and raise money for you. Unless they're a registered broker-dealer, that's raising a red flag. The issue with not complying with securities laws, aside from criminal, potential criminal liability and civil liability for fraud, which, is far less common. The more common issue is, if you just haven't complied with them, but you're not a fraudster, you may have to offer the investors a right of rescission. That is a right to get their money back. I'm sorry, this is why I don't check the chat. The right to get their money back, which is a problem if you've already spent it. Not paying attention to regulatory issues. So especially for early stage companies, many spaces you want to play in are regulated. And, I don't think investors would necessarily expect you to have fully complied with all regulations in those space, because that can be expensive. You got to hire lawyers. But many times what they would expect is that you're at least aware that there's a regulatory framework and you've got a plan to deal with this regulatory risk. And many times, they would anticipate that part of the business plan would include money to be spent on working through these regulatory issues. Not managing your cap tables, that is not getting the right types of agreements in place for vesting or transfer restrictions, so that you've got folks on there who shouldn't be there. Thinking there are standard terms. There, unfortunately, is sort of a continuum of terms that are what we would sort of expect to see. And then, obviously, terms that are not market do sometimes make it in if the business circumstances justify it. But, there are not really any standard terms. So Side letters, we've talked a little bit about them. They are agreements that are outside the standard forms of agreements. They will ask for things like information rights, rights to information on the company that are outside the sort of typical transaction agreements. They will also cover things like board observer rights, which is a kind of observer rights, pro rata rights, right, which is the ability to buy in at the next round, those types of things. Now, what a company would typically not want to do is just have a side letter with each and every investor, because these can be expensive to negotiate, and then you got to comply with them afterwards. Failure to obtain proper corporate authorization. Before issuing stock, you need to make sure you've got enough authorized stock, and the board and stockholders, the board needs to approve it. And to the extent, there needs to be an amendment to the charter, the stockholders have to approve it. So just running around, cutting safes, cutting convertible notes, and/or issuing stock without following the proper formalities can make you end up in a situation where there is a lot of cleanup to be done. Not forming an entity, which could lead to unlimited liability, or not forming the right entity, which can form, either lead to cleanup or could be potentially business killing if you can't get the other stakeholders to agree to the change. Mentioned vesting agreements. Related to vesting agreements, filing 83B elections here in the US, that basically allows you. So the issue there is the IRS will take the position if there's a substantial risk of forfeiture on property. That is, if there's a substantial risk that you could lose your stock under a certain set of circumstances. In this case, you've got stock that's vesting, you leave early, you give up the stock that has the strings attached to it. The IRS takes the position that basically when each of those strings is cut, when those risks of forfeiture lapse, that's when you're deemed to have held the stock. And therefore you got to pay there's tax on the difference between what you paid for the stock initially and the value of the stock when those restrictions lapse, unless you file an 83B election, which basically allows you to prepay your liability initially. Now, of course, that many times will mean that you don't need to pay anything because you basically already paid the full fair market value of the stock. But not filing that within the 30 days that you need to do that can create enormous, sometimes intractable problems. Not paying attention to securities laws is on there twice because it happens all the time. And people say, well, this is just a small company, I don't need to pay attention to them. And the answer is no, you do. They're out there so long as you're selling, stocks, safes, convertible notes, et cetera. It's just, you need to make sure you target an exemption from having to register your company. Lots of risk with respect to employment law issues. So, theoretically, especially out here in California, everybody needs to get paid, minimum wage and in compliance with labor. And potentially that means that there's going to be overtime. That doesn't always happen, especially kind of founders. Many times, folks are sufficiently aligned or feel that they are sufficiently aligned to take the risk. But, you need to have a pulse on what that risk exposure is. And your investors are going to be interested in that and what your plan is. Undocumented stakes in the company. These are napkin promises or emails to folks, kind of giving them a toehold to claim that they have some ownership interest. IP that resides in other entities, whether you're coming out of a university or you're coming out of another company, or, you want to be clever and you want to wholly own, the entity, some entity that's got all the IP. You just need to work through that, make sure that you got the proper licensing and other things in place. And many times your investors are going to insist that, if you got a patent or something like that, that's going to be in the company. Because many times these companies are going to pivot. And so they want to make sure that to the extent there needs to be a pivot, the company's got the maximum chance to do that and isn't going to get leveraged by some founder or somebody else who's got, the patent owner. or other IP. The patent was just an example. And then paying attention to tax issues, right? Like if you're selling it, in other states, are you obligated? Do you need to be withholding sales tax? Those liabilities can accrue as well as the penalties and interest, and that can be a real problem. So I'm going to pause there and take questions and comments. I'm going to focus on questions of general applicability. I really appreciate you hanging in there with me. I hope you've learned a lot. I hope this has given you a good sense for kind of what the path is. How is it that you would get yourself and position yourself to being, eligible and ready for venture capital financing? What are the things that you think about at a high level? Someone is asking about bad lever, good lever provisions. I don't know if this person's in Australia or not, or maybe it's the UK. I feel like I see bad lever and good lever, like those terms that, in those jurisdictions, at least here in the US, we will see it typically built around, termination for cause, and cause would be defined. It could be material breach of a confidentiality agreement with the company, or, pleading guilty, being convicted of pleading guilty to, or pleading, no contest to a felony that is reasonably likely to have a negative impact on the reputation of the company, something along those lines. And stock and other things can be forfeited under those circumstances. But there's a whole host, and actually there is even a separate practice in the law of folks who deal with benefits, and those are the folks who are really kind of the experts in these areas. And that's what we see. Why do VC funding versus personal funding? What is the benefit of VC? Look, VC is a particular kind of model. If you don't, if you can bootstrap your company, you can build a business, do it. But if the business you're trying to build requires extensive amounts of capital, tens, hundreds of millions of dollars, and that company is going to grow and scale over 7 years, plus or minus, and when it grows and scales, it's going to be ripe for some kind of liquidity event, whether that is an IPO, a little bit less commonly these days, a SPAC, as the SPAC market, I understand, is a little bit tough, or an M&A exit. VC is that's a potential model for a VC. And again, it's got to have that sort of growth curve. So this is like a company that every 24 or 36 months is doubling or tripling in value. And so you can kind of see how, at a series seed stage, somebody puts in $1 million, doubles 24 months later. Series A, it's worth 2 million, doubles 24 months later. At Series B, it's worth 4 million, doubles 24 months later. At Series C, it's worth 8 million. You can see how you can get 16 or 32x out of that. But no, I would not say VC is right for every company. I would say there is a particular model. I hope, and I sort of explained more about that at Venture Capital Training Camp, although I did cover it today. And, if you can bootstrap it, do it. How do you know if you found the right VC? So, all right, let me ask you, let me kind of flesh out maybe a little bit more about running a systematic process. One of the things you would do, right, is you would gather research. You can look on Crunchbase, you can look on PitchBook, you can look on their website, you can look on any number of other places. So lots of VCs do a lot of speaking and other things, and you can meet them. You got to do your reverse diligence on them. You got to interview them. You can ask to speak to their portfolio companies. You can ask to speak to folks who were at their former portfolio companies if they've already exited. This is very much, especially early on, the common and the preferred should be aligned. That should be really kind of the goal. And these folks are going to be partners of sorts. The VCs should hopefully, right? It should just be more than just money. There should be additional value add there, whether that is industry expertise or, access to experts or suppliers or customers. You should be able to hopefully get more value out of that. Can you talk more about a virtual data room? So hopefully folks here have used Box or Dropbox, but a virtual data room is really just an electronic repository with a bunch of files, file folder structure, where documents are going to be placed. And you will get a due diligence request list, and it might be broken up into 7 sections. It might be kind of all corporate books and records. It might be all intellectual property rights. It might be, any litigation. It might be all material contracts. It might be all subsidiaries. And there might be some miscellaneous. And then within there will be questions like, give us all of your stockholder consents or minutes. Give us all of your board consents or minutes. And so there will be subfolders within the corporate section. And it's in there. That's where all your documentation gets loaded there. Yeah, okay, so we've got a company that's not an IPO path. What should we be doing differently to make ourselves an acquisition target? I'm trying to think. The number of companies that have a successful exit, and there are lots of companies that have unsuccessful exits. Number of companies that have successful exits, via an IPO versus an M&A event, I think it's like maybe 100 to 1, something along those lines. I mean, the number is like the vast majority of exits are going to be M&A exits. And so I think, focusing on, what's maybe a little bit different. I mean, focusing on who your target acquirer would be, right? Is that going to be a strategic play, right? And if you're going to be potentially selling to a strategic, what does that market look like? Is that only a market of 2 or 3, or are there 5 or 10, right? And sort of thinking about what the synergistic value could be that you might be able to unlock if you could sell, and sort of maybe building out the company with that goal. Or is it going to be more of a money play? Would you be selling to like a PE fund or and sometimes you'll run a dual process of that, and so I think those are maybe a little bit some things that I think about being a little bit different than an IPO path. But I will tell you, first and foremost, the vast majority of exits and liquidity events come from M&A as opposed to IPO. But not everybody, but many people, many entrepreneurs, especially right at the outset, are focused on IPO. Hope that was helpful. And feel free to, send me an email if you want to connect at office hours. If you get angel funding first, is it more difficult to get a VC on the board later? No, absolutely not. I mean, it is sort of traditional that an angel, that is an individual with, a wealthy individual or groups of wealthy individuals who are hopefully accredited investors, which is defined in Reg D. Typically these are people who individually make over $200,000 a year, or as a married couple make $300,000 a year, or they have sufficient assets. Those are the folks who will be making the first investments. Those angels will be the first investments. And so many times, those are the people who kind of take the most risk, and what motivates them really is a broad gamut. It might be friends or families. It might be folks who are interested in the particular technology. We see that a lot in the climate and energy space that I work in. So no, it's not more difficult at all. Do you commonly ask a VC to sign an NDA? you in the life sciences space that comes up, it's pretty rare in almost any other space, but it really just depends on whatever space you're in. So, I mean, most VCs will say, well, we never sign NDAs. And that's not entirely true. Like it does come up, especially in the life sciences space. So there's like a little bit of a corollary there that I'm not giving you advice, but I would tell you, think about this. When you have an NDA, or excuse me, when you don't have an NDA, or especially if you're an early stage company, you do have an NDA. The problem with being an early stage company, or even a more secure, more established company, you've got an NDA. Well, sort of they breach it, you got to enforce it. That means you got to hire lawyers. That can be tens, hundreds of thousands of dollars to do that. The most control you have, or the best kind of defense you have, is to be mindful of what information you're sharing. So high level at first, right? Then maybe start to zoom in a little bit after you start to build that relationship. And of course, by the time you've got a signed term sheet, you're going to need to open up the kimono, as they say. So, let me just see. Bear with me again. I'm kind of running the tech in the background as well. Got it. Maintenance. Bear with me one more second here. Just cleaning up something. What are popular VC and angel investment sites that we can shop around for investors for? So again, you can get a, I'm not sort of championing any of these, but you can get access to Crunchbase relatively inexpensively. You could probably get even a trial run at PitchBook. TechCrunch has a lot of good information on it as well. And, it's not necessarily shopping around as it is probably building your list and learning about them to see if they'd be a good fit. But then you got to do some additional diligence, right? Checking out their websites. You got to understand, ideally, you'll also be understanding the past deals that they have done, what space they're interested in, and even better, what partner at that fund is interested in that space, because that's the person you should probably be working with. You probably don't want to connect and share confidential information with a VC that's invested in a competitor. But if they've invested in a business that is sort of complementary or synergistic to yours, that might be a good potential play. Hopefully that's been helpful. Who is in the lead in the US in your experience, driving an exit, founders or investors? Of course, the majority decides, but how often? The question is, who's been in the lead, founders or investors for exits? Let me think about that for a second. I mean, I think it really just sort of depends on the company itself. I hate to be wishy-washy. I mean, usually founders are interested in getting some liquidity and that's because, they've typically put 7, 9, 10 years into a business. To the extent you've got VCs who are interested in sort of getting their money back, if you will, especially later stage ones, then you might see them put redemption provisions in the charter. Many times we'll see in the investor rights agreements, there will be a provision where the investors can kind of, force a company to file an S1. But that's usually not used to force the company to go public. That's usually used if the company has gone public, but then they've let their filings lapse. And then the other thing to keep in mind, especially with VC investments, is that, the rights that they get are usually negative control rights rather than affirmative control rights, meaning they can block things rather than drive things. So it's usually they all get aligned on it, I would have to say. Sorry, I'm just taking a look to see if there are any other. Huh. Question about handshake deals. Are they legal? So talking about here in the US, I mean, that's one of the sort of perils of, okay, so the question is like, are handshake deals or verbal agreements legal? I mean, generally speaking, at least here in the US, yes, they are. The problem is they can get you into trouble because you haven't documented what everybody's expectations are for the innumerable set of events that can come up. Additionally, there can be problems enforcing them, especially if we're talking about deals that involve real estate or sales of goods or other things like that, because there's something called the statute of frauds, which says basically, if it were easy to, as easy as just verbally convey real estate that has changed title, then everyone would just go run around and say, oh, well, so-and-so gave me or sold me the property to their house or or the lease that they entered into. So handshake deals in one sense are legal in the US. In another sense, you can have some real problems, and especially around enforceability. And that can lead to disputes and lawsuits. And, one sort of maxim here is that nobody wants to invest in a lawsuit. So if you're going to be raising venture capital, and one reason why there's so much thorough diligence is that nobody wants to invest in a lawsuit. It's risk, again, that can detract from being able to hit that upside that the VCs need or want in order to make their portfolio work. So, if there is a handshake deal, that usually comes up in diligence, and then it's going to be a cleanup item to get fixed. And fingers crossed you can get that done. Great. Oh, question. Are all forms of investments, debt, equity, equivalent when it comes to get investors getting a board seat? I mean, sort of traditionally, no. Well, traditionally, no. I would say most of the time, if you're talking about seed stage investments, investors not going to get a seat on the board, especially if you're raising from friends and family. If you've got an institutional investor, maybe a micro VC or something, then potentially. But many times, up through Series Seed and maybe even Series A, and those are squishy terms, which we're not going to have time to get into today. It might be possible that you can raise $5, $10, $15 million and not have given away a board seat, if you will. At the same time, many times companies have already given away the board seat. And one of the real concerns or thing that you need to think through is it appropriate to give that investor a seat on the board, or for what duration, right? So rather than being in perpetuity, maybe it's kind of until the next round or some specific point in time. Because one of the problems is once you get people on the board, sometimes it's hard to get them off, and you don't want to have an unwieldy large board, or it becomes very difficult to make decisions. These companies, especially at the early stage, need to be able to move quickly. Question is, does each seat on the board carry the same weight? Statutorily, unless it's documented in the charter, yes, they do carry the same weight. Again, certain protective provisions and other things in the charter will provide, or typically will provide, that you will also need to get a preferred directors sign off on something, like whether it's the budget or whether it's the incurrence of a certain amount of debt. But sort of as a general rule, again, I can't give you legal advice here, but as a general rule, board seats do carry the same weight. But you will also see that that'll get modified a little bit. All right, and with that, we close the hour and a half. I want to thank Idea to IPO for organizing today's event. I want to thank my firm, K&L Gates, LLP, for supporting it. I want to thank each of those live attendees for sticking with me and making it to the end. For those who are watching on a time-shifted basis, thank you so much for signing up and viewing. I'm Jason Putnam Gordon, an emerging growth and venture capital attorney. Feel free to connect with me on LinkedIn if you want to, follow me and see what other events I'm doing. And with that in mind, I'm going to sign off and let you get back to building your great company. Thanks a lot and have a great night. Bye-bye.